But meanwhile, let's now shift our focus to a landmark judgment from the Supreme Court, where it has now said that mere storage of child pornographic material is also an offence under the Protection of Children from Sexual Offences Act, which is the POCSO Act. Now, the top court has set aside the Madras High Court's order, which said that mere downloading and watching child pornography is not an offence, calling it an egregious error in the passing of the judgment. In fact, the centre has been also asked to bring in an amendment to replace the word child pornography with child sexually abusive and exploitative material. Courts have also been asked not to use the term child pornography going forward.
The Supreme Court has said henceforth the courts must not use the word child in fact the child pornography, saying it's a very limited and narrow usage because it involves a lot of exploitation of young children, even toddlers, and said that henceforth it should be child sexually abusive and exploitative material. In fact, so widening the ambit and ensure that such kind of exploitation is better dealt with. So the Parliament has been asked to make an amendment in the POCSO Act in this regard, and courts also asked to refrain from using the narrow word like child pornography. The biggest takeaway is that the Supreme Court has struck down the Madras High Court judgment, which had said that merely downloading and watching child pornography is not an offence under the POCSO or the Information Technology Act, and has said that yes, it is an offence just like creating, publishing, disseminating, transmitting, especially for financial gain and other benefits, which makes it an all the more graver offence. So this is what the Supreme Court said, also noting that use of children for making porn is a very, very grave offence and has to be seen like that.
With that, viewers, let's slip into a short break. Don't go anywhere. We'll be right back.